Perayu-554-10/2019, Perayu Jin Haifang, Responden Syarikat Pengangkutan Satu Hati Sembilan Berhad, dipanggil bersama dengan kes nombor 20 dalam senarai J-04 NCVC-555-10/2019, Perayu Zhu Cunhua, Responden Syarikat Pengangkutan Satu Hati Sembilan Berhad.
Ya.
Silakan, Yang Arif.
Please, my lord, my ladies, allow me to introduce the parties. My name is KFE for the appellant plaintiff, and my learned friend appearing for the respondent defendants are Encik Azizi, and together with him is Puan Nurul Dalilam.
Yeah.
Yeah, Arif, it has been agreed that these three appeals will be heard together,
Yeah.
because it involves the same facts, same question of law, whether stay of execution should be granted or not.
Yeah.
And it is also agreed by both parties that we will just submit on one case will do, and that is case number 552. Appellant plaintiff is Mr. Zhao Fangliang. Whatever the outcome of this appeal will be binding on the remaining two appeal number 554 and also number 555.
Okay.
So probably can my learned friend confirm?
Yes, I do, my lord, my lady.
Zizi?
Yes, I confirm, my lord.
Yeah. Okay. So before we go any further, can we put on record that parties confirmation that the appeals before us today was fixed and is going to be heard at the request of both parties, and that the parties also agreed to the mode of hearing the appeal today by virtual court held over live streaming.
That is so, my lord.
Yeah.
I confirm and I agree that is so, my lord, my ladies.
Yeah. Abang Mr. Azizi also confirm, huh?
I confirm, my lord.
Yeah. Okay. You may proceed. You have how many issues, Mr. E?
I have only one issue. Can I trouble my lord, my lady, to look at my submissions, enclosure number 9?
We have read your submission. Yeah. Never mind. Yeah.
Enclosure number 9. This is the appellant plaintiff written submissions. I would page 2. The page number is written at the bottom of the page 2.
Yeah.
Can you see that, Yang Arif?
Yeah.
Yes.
Okay. I'm going to briefly introduce the background facts of the matter. There was an accident,
Be brief lah.
a motor vehicle accident on the 7th of October 2015 involving 20 China tourists. And as a result of that accident, 4 tourists were killed and the balance 16 were injured. I acted for 4 deceased family and 1 China tourist who suffered personal injuries. The trial proceeded, concluded, and the Session Court of Batu Pahat on the 24th of January 2018 pronounced the judgments.
Yeah.
And after the pronouncement of the judgment by the Session Court of Batu Pahat, both parties filed the respective appeal on the quantum of damages.
Yeah.
Both parties appealed. And then I'm at page 3 of my submissions, at the bottom of page 3. It's written at page 3 at the bottom of it, paragraph 5. And the High Court of Muar on the 14th of May 2019 had pronounced the judgments after hearing the appeals. All right. And again, both parties also filed appeal further to the Court of Appeal on the issue of the quantum of damages. Meanwhile, while both parties were filing an appeal back then to the Court of Appeal, meanwhile, the respondent defendant had filed an application for stay of executions at the Muar High Court. And the Muar High Court had on 25th of September 2019 allowed the stay of executions. All right. So my main submission is this.
It's a conditional stay, isn't it, Counsel?
Yeah.
Conditional stay subject to the payment of the balance judgment sum into your client's account.
Correct.
You have received it.
I have received it. I confirm I've received it. So the issue right now is this. Before, immediately after the session court delivered the judgments, both parties have a written agreements in the form of exchange of correspondence between both parties. And this written agreement, I will call that a settlement agreement because it's laid down the terms how to pay the judgment sum. In this regard, may I invite my lords, my lady, to refer to Ikatan Trust Bersama Enclosure 11.
Yes.
Can I go to page 1 first? Look at page on the right hand side, the page 1, which has been prepared by us. Page 1. Can we go to page 1 first? Are you with me, Yang Arif?
Yes.
Yeah.
Okay.
Yeah.
This is the High Court order at dated 25th September 2019. This is order Kandungan 31 and at page 2, allowing stay, conditional stay of the executions. Paragraph 1 is stated that the balance 50% judgment sum to be paid to my client's account. This has been done. And paragraph 2 is further ordered that the 5% per annum on the balance 50% judgment sum to continue to run until the disposal of the appeal at the Court of Appeal. So basically, this is the High Court order pertaining to the stay. And can I invite Yang Arif to refer to page 6 of the Ikatan Trust? The paging number is on the top right-hand corner, prepared by us, page 6. This is a letter from my learned friend, Mrs. Omar Hashim, dated 6th of March 2018.
Yeah.
Okay. You're with me, Yang Arif?
Yes.
Okay. So this letter was issued after the session court pronounced the decisions.
6.
So can I read paragraph 2 of the letter? Further to the discussions, we write to confirm that our client is agreeable to release 50% of the judgment sum to your clients, and the balance 50% of the judgment sum be retained by our client pending disposal of the appeal in the Muar High Court. So the keyword is, back then, 50% judgment sum to be paid first. This has been done back then, and the balance 50%, Mrs. Omar Hashim will keep pending the outcome of the appeal at the Muar High Court. And then this was confirmed by my letter. Can I refer to the next page? Page 7.
7.
This letter issued by KFV & Co., that is my firm, dated 7th of March 2018. Paragraph 2. Allow me to read paragraph 2. First and foremost, we thank you for your said letters dated 6th of March 2018. That is the letter at page 6, just how I just referred.
Yeah.
And then, can we skip to the next page 8, paragraph 4?
Yeah.
Paragraph 4 of the letter. This further serves to confirm that the remaining balance payment of the judgment sum shall be retained by your client pending the disposal of the party's appeal in the Muar High Court. And the next page, Roman 2, to be paid to us as solicitor for the plaintiff upon the disposal of the party's appeal at the Muar High Court with interest flowing therefrom, and or to be paid to us as solicitor for the plaintiff on whatever variations of the judgment sum ordered by the High Court in Muar with interest flowing therefrom.
Yeah.
So it's very clear there is a valid binding settlement agreement. Very clear? Upon the appeal being disposed by the Muar High Court, according to these crystal clear terms of the settlement agreements, the balance 50% is to be paid to my clients, not to be paid to my client's account pending the disposal of the appeal at the court appeal. So, can I refer to page 11?
Page 11.
This letter,
Yeah. Your letter.
yes, dated 16 of May 2019, after the two days after the High Court decisions on appeal. Can Yarif, are you all with me, Yarif?
Yes, yes.
Yeah.
All right. We refer to the above matter and outcome of the decisions on 14th of May 2019. So the decisions was pronounced by the High Court on 14th of May. And then can I straight away skip to page 15,
Yeah.
paragraph 3.
Yeah, yeah. Para 3.
Meanwhile, pursuant to the agreement reached between both parties contained in your letter dated 6th of March 2018 and our earlier letter dated 7th of March 2018, that the balance variation of judgment sum to be paid to us as solicitor for our clients upon disposal of the appeal by the Muar High Court. As such, kindly be advised to pay up the balance variation judgment sum within 14 days from today. So immediately after the High Court decisions, we sent a letter to demand the balance 50% judgment sum. And then let's see what is their reply. The reply is contained at page 20. At page 20 is a letter from Oman Hashim dated 10th of July 2019.
Yeah.
Can you, are you with me, Yarif?
Yes, yes, yeah.
Paragraph 1, 2, 3. Paragraph 3. Pursuant to the telephone conversations. Can you see that, Yarif?
Yes.
Pursuant to the telephone conversation on the 13th June 2019 and 26th June 2019, we write to reiterate the discussion that we have a client instruction to propose to your client that the balance of the judgment sum for the award made to all the plaintiffs, except Zhang Xuerong, be further held by our client to or be deposited into your firm's client's account to be held as a stakeholder pending disposal of the above appeals. So right now, from this paragraph, it's very clear they make a change of their stance. They departed from the agreed terms of the settlement agreements. Well, and then the following paragraph, allow me to read. We understand from Mr. James E. that the above proposal is rejected by your clients. In that circumstances, as per the telephone conversations, we have notified you that we have a client instruction to file an application for stay of execution on the judgment to the Muar High Court, and so on and so on. So that is the start of the application of the stay.
Application for stay.
Yes. And
when the application was filed, actually?
The stay application was filed on the 8th of July.
The High Court, and not before the Session Court, the
High Court, 8th of July 2019.
Yeah.
8th of July 2019. The notice application for stay of executions.
Yeah. Okay.
And then let's go on to look at my letter of reply at page 23.
23. Yeah.
This is a letter from KFE and Co. dated 15th of July 2019.
Yeah.
And can I straight away dive into page 24, paragraph 5?
Yeah. Yes.
Yeah?
Yeah. Furthermore, it's
Satu Hajam?
yeah.
Are you with me?
Yes.
Yeah.
Okay. Paragraph 5. Furthermore, it is so crystal clear in your very own letter dated 6th of March 2008 that the balance 50% of the judgment sum to be released to us pending the disposal of the appeal by the Muar High Court. Hereinafter to be known as the said agreement, and this is further confirmed by our letter dated 7 March 2019, particularly paragraph 4, sub 2 and 3, which is being reproduced for your easy reference.
Yeah.
So, at the bottom of the letter, based on the said agreement, we have agreed not to proceed to enforce the judgments granted by the Session Court in Batu Pahat against your client to recover the judgment sum. In the light of the circumstances, it is not honorable on you and your client to renege on the said agreement, refusing to pay us the balance 50% judgment now. Your client is an international large multi-billion insurance institution with good reputation worldwide, and for a client to dishonor the said agreement to pay the balance 50% judgment sum certainly would jeopardize your client's reputation globally. Your client's deliberate act not to honor the said agreement to pay the balance 50% judgment sum to our client is certainly an act of oppressions, bullying tactic on our clients who are ordinary commoners, dependent on the judgment sum to support their living expenses after losing their loved one in the fatal accidents. Despite the twisted terms in your very own letter dated 6th of March to release the balance 50% sum after the disposal of the appeal by the Muar High Court, it is equally dishonorable on your part to now mislead, twist and turn the factual metrics to argue otherwise. Black is black, white is white. Based on the terms of the said agreement, there is certainly no room for you to argue it is grey. And can I go to paragraph 7? At this juncture, we would not want to deliberate on the merits of the client's appeal as it is a matter for the Court of Appeal to decide, and this is certainly not a factor to be considered in application for stay of executions in accordance with the tried law, which require no further elaboration presently. As such, there is certainly no special circumstances for application for stay of executions. Paragraph 8. It is certainly an afterthought and lack of bona fide for you and your client to rely on the excuse that is no reciprocal of enforcement or judgment between Malaysia and China when you were fully aware of it before your client acceded to the said agreement. So that is basically the background leading to the dispute, leading to the application of the stay of executions. So may I go to the law, Yang Arif?
Yes.
Can I come back to my submissions? Enclosure 9, submission, paragraph 22.
Question 9.
It's page 9 at the bottom.
Yeah.
It's the paging number is at the bottom of the submissions.
Question 9. Huh?
Yeah. Are you with me, Yang Arif?
Yeah.
Okay, paragraph 22. I'd like to refer to this case of Yayasan Melaka versus Fortran Corporation Sdn Bhd. Is a High Court, and then I quoted the paragraph 13. At the bottom of it is being highlighted and bold, the written contract. Can you see that, Yang Arif?
Yeah.
The written contract declared in explicit words that the terms of the agreement are to be found in the writing. And in the writing exclusively, in face of these provisions, it is not, in our opinion, competent for a court of law to resort to contemporary conversations or prior conversations or even to the legend on the article for the purpose of discovering a contract differing in its terms from what from that has been expressed in the unambiguous language of the instruments.
Counsel, we are not disputing those legal principles in interpreting contract. The question is, when there was an agreement by way of exchange of correspondence while awaiting the outcome of the High Court of Muar's decision and disposal of the appeal, was there also an agreement that arising from the appeal, neither parties shall proceed with further appeal, and that neither party shall proceed with any stay of execution of proceedings? It was silent on that, I think. It could have been clearer, but it was silent on that. So can we say that the defendants have bargained away their right to appeal and to, in the meantime, apply for some stay?
Yeah, Arif, with due respect, I beg to differ. There is, in the settlement agreement, nothing to prohibit neither parties from appealing further to court appeal. This is not the issue here. So right now, the issue here, it is very clear in the settlement agreements when the defendant has agreed to pay up the balance 50% judgment sum upon disposal of the High Court appeal. That simply means there is no more room for them to apply for a stay. You cannot. They
bargain away their right to apply for a stay.
Yes, they bargain away their right to apply for a stay of executions. By applying for a stay, that go against the spirit of the settlement agreements. Arif, there are many cases in my submissions which the Court of Appeal and the Federal Court, they have already said the sanctity of the agreement must be upheld by the court. When the terms of the agreement is so crystal clear, the court should not interfere.
It would be crystal clear if it is written in the agreement, a clause to the effect that parties shall, after the disposal of the High Court's decision in Muar, shall not appeal or shall not apply for any stay pending appeal.
There is no necessity, Arif, to state what is already so clear in the settlement agreement. In the settlement agreement, it's already stated upon disposal of the High Court appeal, you immediately pay up the 50% judgment sum. That is so clear, you already bargained away your stay of executions. There is no necessity to clarify what is really very clear in the settlement agreements. Arif, there is no necessity. What is already stated so clearly there is no need to further explain. You have bargained away. There's no need to expressly state in that settlement agreement, you have no right to apply for a stay of executions. Because I would like to draw, Arif, Datuk Lee, since you're on these questions, can I draw your attention to one case? This case is a very interesting case at page 14 of my submissions, where the legal principle there and the facts over there, the legal principle there is somehow similar to our present case here. Page 14 of my submission, the case of Jurutera Consultant.
In that case, it was stated that their settlement was such that the decision of the High Court will be a full and final decision.
Yes.
And neither parties shall appeal.
Yes. Yes.
So yes. It's stated in express terms.
Yes. Arif, this letter is very clear. What is the meaning?
Could be clearer.
Arif, is clear enough. It is already clear enough, Arif. What is the meaning? Upon disposal of the appeal, you pay out 50% balance judgment sum.
It doesn't prevent them from applying to court for a stay pending for the appeal.
Well, that goes contrary to the spirit of the settlement agreement.
But does it go to the issue of the discretion of the court?
Yarif, if there is no settlement agreement, well, the legal principle of stay of executions will apply whether it's a special circumstances or not. That one is a discretion of the court, whether there are special circumstances to justify a stay of executions. But here, we have a settlement agreement. And
Well, settlement agreement is a limited settlement agreement. It is a limited settlement agreement confined to the condition of stay pending the disposal of the matter by the High Court in Muar. It is limited in that sense. It is not a full settlement agreement. Unlike the case of Jurutera Consultant.
Both parties, they have the right to appeal further to court appeal. This is not an issue.
Yeah, no issue.
So right now,
the issue is whether they have a right to apply for stay. Have
Yes.
they bargained away that right?
certainly they have bargained away the right because the terms is so clear. What could be more clearer than what has been stated in the letters? When you say upon the disposal of the appeal by the High Court, I will pay you 50% balance judgment sum. Simple as that. And that actions, you have made a promise in your agreements. Upon this pronouncement of the appeal at the High Court, I will pay you 50% judgment sum. Simple as that. By you applying to the court for a stay, that means you yourself, you are breaching your own promise to pay the balance 50% judgment sum. The terms of the settlement agreements are crystal clear. Anybody, ordinary citizens on the road were to read this letter, it's very clear.
Okay.
But the so-called agreement, the said agreement, it falls short of covering an appeal to the Court of Appeal. So it is not a complete agreement, as my learned brother has stated.
No, Yang Rif. We are saying whatever the outcome of the High Court appeal, you pay the balance 50% judgment sum. You can appeal further to court appeal. That is your right. That is my client's right. There is no dispute about it. You pay the balance 50% judgment sum first. I'm not stopping you from appealing further to the court appeal. Neither you are stopping me from appealing further to the court appeal. That is a separate issue. We are not stopping each other from appealing further to the court appeal. But whatever, doesn't matter whatever the outcome will be by the court appeal later on, at this point of time, as per our settlement agreement, you pay up the balance 50% judgment sum. That has been agreed upon in the settlement agreement. Crystal clear. The letter say, very simple, letter say, upon disposal appeal by the High Court, I pay you the balance 50% judgment sum. But they have not honored it. They did not pay the balance 50% judgment sum to us. So they can appeal further to the court appeal. We are not stopping them. We are not stopping them from appealing, neither they are stopping us from appealing further to the court appeal. But the settlement agreement is very clear, irrespective of whether you appeal to the court appeal, whether you're successful in a court appeal or not, you have to pay the balance 50% judgment sum now, after the disposal of the High Court appeal.
Okay.
Very simple, very clear in the letter. When you already say you pay the 50% balance judgment sum, it simply means you cannot stay the execution of a judgment.
Okay, Mr. A, I think not to prolong that issue, can you move on? We take note of your submission. We take note of your submission. Can we move on to other issues?
Well, Yang, I just want to stress one more point.
Yeah.
This is a very the terms of the settlement agreement are very clear, and then we do respect to the learned High Court judge. By granting the stay of execution judgments, this is a very dangerous precedence. open a floodgate. In future, no point for any litigants to enter into settlement agreements and so on and so forth, because either party can still apply to the court for a stay. So the sanctity of the agreement must be upheld, Yang Arif.
So you see, what was the reason the High Court judge grant the stay?
Okay, Yang Arif, can I go to the ground of the judgments? The ground of the judgments is at enclosure 7. Page 33. The page 33 is the right, at the top right hand corner, page 33, enclosure 7.
Dengan izin Yang Arif, dokumen tersebut ada di dalam ikatan khas Yang Arif. Alasan penghakiman, di bawah tajuk alasan penghakiman. Arif.
Ya. Rekod rayuan tambahan.
Ya.
No, additional appeal report. Was it in the additional appeal report? Penghakiman is there, page 1 to what page?
Page 33.
Page
33, Yang Arif.
33. Ya,
Okay.
alasan penghakiman.
Page 33 is alasan penghakiman. Can I straight dive into the relevant paragraph at page 40?
Yeah.
Page 40.
Para 13, is it?
Paragraph 14.
14, okay.
Paragraph 14. Paragraph 14. Dalam kes ini, defendant telah menjelaskan 50% wang penghakiman kepada plaintiff. Pada pendapat mahkamah, jika baki 50% lagi dilepaskan kepada plaintiff dan jika rayuan defendant di Mahkamah Rayuan dibenarkan kelak, maka keberangkilan untuk defendant mendapatkan semula jumlah yang telah dibayar adalah mustahil. Ini adalah kerana plaintiff merupakan warga Republik Rakyat China yang menetap dan berstauting secara kekal di negara tersebut. Tambahan lagi, Republik Rakyat China bukanlah negara yang tersenarai di bawah jadual 1 Akta Penguatkuasaan Penghakiman Bersalin 1958. Akibat ketiadaan apa-apa reciprocal agreement on the enforcement of judgment between the two countries, maka defendant penanggung insurans tidak akan dapat memkuatkuasakan sebarang tindakan undang-undang untuk menuntut kembali jumlah penghakiman yang telah dibayar dan tidak dapat dipampaskan dalam apa cara sekalipun. Rujuk kes Lau Nam Hui, Fangliang. Seterusnya, perenggan 15. Mahkamah mendapati bahawa penanggung insurans iaitu Alliance General Insurance Berhad adalah salah satu syarikat insurans yang tertakluk di bawah Bank Negara Malaysia dan merupakan pemegang wang amanah dari dana awam dan mempunyai tanggungjawab untuk melindungi dana awam tersebut. Paragraf 16. Oleh itu, mahkamah berpendapat bahawa jika wang baki 50% daripada jumlah penghakiman tersebut dilepaskan kepada plaintiff, maka defendant boleh dianggap telah melanggar amanah dan tanggungjawab untuk melindungi dana awam tersebut yang mana bertentangan dengan public policy apabila wang tersebut tidak boleh diperoleh semula daripada plaintiff. Plaintiff pula tidak pernah memberikan jaminan yang wang itu akan dikembalikan jika rayuan defendant di Mahkamah Rayuan dibenarkan. Seterusnya rayuan akan menjadi sia-sia. Bagi mengimbangi keselesaan dan keadilan kepada kedua pihak, maka mahkamah memutuskan bahawa 50% jumlah baki wang penghakiman tersebut dipositkan kepada akaun penguacara plaintiff, iaitu Tetuan KFV & Co untuk dipegang sebagai stakeholder dan dipositkan ke dalam akaun simpanan tetap sementara menunggu penyelesaian rayuan di Mahkamah Rayuan. So, Yang Arif, can I go back to paragraph 14 of the ground of the judgment first? I will address the issue one by one. Where paragraph 14. paragraph 14 of the ground of judgment simply says that because China and Malaysia, there is no reciprocal agreements, and therefore, there is it is difficult for the defendant to recover back from my clients. First of all, my rebuttal is this. It is erroneous, with due respect to the learned High Court judge, for him to make a prejudgment whether the court appeal will allow the defendant appeal or not. This is speculations. The merit of the appeal does not constitute special circumstances, as we all know, that is tried law. Number two, assuming if the court appeal allow the appeal and order my client to refund the money, it is also a prejudgment for the learned High Court judgment to say that it is impossible for my clients to refund the money. It is some sort of like making a prejudgment that my client will certainly not be honorable to refund the money if ordered to be done so. Again, this is also speculative.
I think the judge is just considering the difficulties involved with respect to recovering that sum of money from your client in China, unless you have an expert opinion attached to your affidavit in support of your appeal to say that the procedure is just 5 steps. This is someone who is an expert in China law.
Okay, Yarif, very good question. I'm just about to come to that. Okay, there is no agreement between Malaysia and China in respect of reciprocal agreements, but to say that there is no legal procedure available for the defendant to recover the money from the plaintiff is simply erroneous, because according to the case law, which I have just emailed yesterday, PNG Oxygen's melawan Lim Kok Chuan.
Yeah, we have read that case. That is because of a Commonwealth country. They fall back on common law. Huh? I'm sure there must be something in China, but we don't know what it is unless you have an expert opinion to that effect. So why go through the uncertainty of it? That's all that the judge is saying. He's not speculating. He's just saying something which is reasonably foreseeable. That's all.
Yarif, the burden is on the defendant because the defendant made applications for stay of executions. So the defendants, in their affidavit of support, in their affidavit in reply, they should attach a legal opinion from a China lawyer to say that there is no legal procedure for a Malaysian company to recover the judgment sum from a China citizens. The burden is on them. And for them to just come and say that there is no way for them to do so, that is erroneous when they have not consulted a legal opinion from a China lawyer. That is just a slipping statement. Yarif, this case of PNG versus Lim Kok Chuan, this judgment was issued by Papua New Guinea. Papua New Guinea is not a signatory to this reciprocal enforcement of judgment agreement with us. And yet, our Malaysian court allowed common law to register the foreign judgment, despite they are not a signatory to a reciprocal enforcement of judgment act with Malaysia.
Yeah, China is not common law. China is not Commonwealth country.
So,
how to apply common law rules?
Arif, that is a question not for any one of us to answer. You and I, we are not familiar with the China law. What the applicant should have done is the applicant should have sought a legal opinion from a China lawyer and put in an affidavit and say, no way Malaysian company can recover this money back from China. I'm given to understand a few months ago, all right, there is such procedures in China proceedings, but I didn't go into further into that. The burden is on the defendant to say there is no such proceeding in China. It's not on me.
From my understanding, there is understanding with respect to arbitration award only, but not on not that I know of about any civil suit.
I beg to differ. So right now is this, Yang Rif, let's not go into speculations.
Yeah.
My submission is this: if it's true that Malaysians cannot recover the judgment from Chinese citizens, if it's true, there's no such legal procedures in China law, the defendant should attach a legal opinion in an affidavit, which they have not done so. Okay. The burden is on them.
Yeah, you got
so right now, what if in China there is such legal proceedings to allow recovery of a judgment sum? What if there is such proceedings? Isn't it we are bring to prejudging right now? Isn't it we go into the uncharted water and make a wrong decision based on the wrong assumptions? And furthermore, Yang Arif, the most important thing is this: when the settlement agreement was entered, defendant was fully aware China is not a signatory to this reciprocal enforcement of judgment. Defendant was fully aware China is not a member country to this reciprocal enforcement of judgment act with Malaysia. They were fully aware. How can they right now raise this argument, China is not a signatory with us? This is an afterthought.
Yeah. Yes.
So they were fully aware China is not a signatory with us on this, and yet they proceeded to sign the settlement agreement with us. And right now, how can they raise this argument right now? This is a clear-cut afterthought.
Yeah.
And the next, I'd like to address the next paragraph of the ground of judgments, paragraph 15 and 16.
Yeah.
Paragraph 15 and 16 of the ground of judgments, the learned High Court judge say that the insurance company is under a duty to take care of the fund, public funds. First of all, with due respect to the learned High Court judge, the premium collected by the insurance company is not the public fund, because it's very simple. I would like to urge this honorable court to take judicial notice. Look at the profit and loss audited account of all the insurance company in the whole of Malaysia for the past 30 years. When they make profit, they distribute the dividend to the shareholders. When they make losses, naturally, the shareholders have to cop out by putting in more fund into the company. So this is a business venture, individual business venture carried out by the insurance company. Whether they make money or whether they lose money, that is the shareholders of the insurance company they got to face. When they make money, they don't distribute the money to the government, they don't distribute money to all of us. So it's erroneous for the learned High Court judge to say that insurance company is a trustee, take care of the premiums, which is a fund of the public, is public policy. I disagree with that. And number two, Yang Arif, again, fall back on this settlement agreement. This is a commercial decisions. This is a commercial decisions taken by the insurance company when they enter into this settlement agreement with my clients. They cannot come now and say that, oh, I'm a insurance company taking care of the fund. I'm not supposed to disperse money to you. They were fully aware of this when they enter into the agreements. When they enter into the settlement agreements, they were fully aware of all these risks. So it is not fair to my clients right now to be deprived of the 50% of the balance judgment sum which has been clearly stipulated in the settlement agreements.
And then not to repeat yourself, Mr. E.
All right. I think that will be all for my submission for today. Unless there is any question from Yang Arif, I'm prepared to assist to address.
That money is earning interest at 5% per annum.
No.
That money that is placed in your account.
That money is placed in the FD account.
Yeah.
The interest, if I'm not mistaken, it's not 5%. Now we can't get
they have to
5%.
top up. The defendant has to top up because interest still runs at 5% per annum.
Irrespective of the interest amount in the FD, the defendant still have to top up 5%. That is
Yes.
the order in the High Court judgment.
Yeah. Mr. A.
Yes.
Any date yet fixed for the proper appeal?
The appeal has been fixed on the 30th of July.
Say again?
The appeal, the appeal on the
Full merits, yeah.
full appeal is 30th of July.
So it's coming up soon.
So Yang Arif, that is irrespective of whether soon or 1 year or 2 years later. Agreement is an agreement. You got to honor your agreement. If had the defendant honor the agreement, we will not have, at a point of time, we were in the process of executing the judgment. At the
So the
session
money is, for the moment, the money is very safe in your client's account. I check up the time deposit interest rate in China is only 3.35%. Their savings interest rate is only 0.39%. So for so long as the money is in your client's account, it is earning interest at 5% per annum. And that's very much better for them. But granted, your client has the right to use it, whatever he wants to use, however he wants to use the money. Granted.
Yeah, Arif, the money they would use to buy a house there, within a year, the property will flip double.
No, we are not too sure in the light of COVID-19. We are not too sure.
Of course. Have they honored the agreement to pay, that is the 2018 May, have they used the money has been doubled. All these are speculations, Yang Arif.
Yeah, we won't enter into it.
Yeah. Okay.
Right. Let's move to what is in the agreement.
Yeah.
Okay. That's about all. Huh? Okay, we hear from Azizi. Mr. Azizi.
Dengan izin Yang Arif, just to reply a bit on this issue on the so-called of the what happened and transpired between the decision which has entered, delivered by the Sessions Court judge, and that during the appeal of the matter in the High Court of Muar. What happened, Yang Arif, at that point of time, what the parties concerned was how is going to be the mode of payment pending our appeal to the High Court of Muar. So at that juncture, we consensusly agreed that without us defendant filing any application for stay of execution, in consideration thereof, we make payment directly to the plaintiff on 50% of the judgment sum, and our client will retain 50% out of those judgment sum pending disposal of the appeal. So that was the position of the parties. I would say that submit that it is in the natural course of event when at that juncture, that the only live proceeding available between the parties was an appeal from Sessions Court to the High Court. And at that stage, parties were not concerned.
Sorry, Azizi, can you speak louder? I having problem to hear you. Can you speak to the mic?
As I said, at that juncture, parties are not so concerned, and we have not been discussing about what is going to happen to the retention sum should there be any further appeal to the Court of Appeal. Because the understanding was that we are bargaining that we do not have to file any state proceedings in the Sessions Court pending disposal of the High Court appeal. So that was the position. That's the reason why that letter was drafted and sent to the plaintiff solicitor in such a manner, my lords, my lady.
What is the stand, your stand as regard to the status of that letter?
Insofar as that letter is concerned, my lord, the understanding between the party was that we do not have to file the stay of proceedings at the stage of High Court appeal. In that consideration, we are to pay 50% to the plaintiff directly and 50% to still be retained by our client.
So
And
there
we
was
do not-
actually, sorry. So you were actually saying that there was no agreement. What happened after the High Court matter, is it?
No, my lady. That's the reason it was not being stated in my letter, neither in their letter of reply to my letter, my lady.
The question is whether you have bargained away your right to file the further application for stay after the High Court's decision. Your stand is you have not bargained away that right. You have not given it away.
No, my lord, because as far as we are concerned, we are only concerned on what happened during that proceeding in the High Court, my lord. Because at that juncture, if there is no proper stay file, as you understand, I mean, they will just execute the whole judgment against our client. So our concern at that juncture is for mutually agreed that 50% be released to the plaintiff and retain another 50%.
From a layman's point of view, a layman will be asking, when can I get this judgment sum in the Sessions Court? And the lawyers, after the exchange of letter, will probably explain to client, after the decision of the High Court upon appeal, if we still win, the money will be released to you from the defendant's solicitors. That would be a fair advice, isn't it?
But my lord, if I may, but that does not preclude us or stop us from filing in another stay of execution to the High Court pending the disposal of the appeal in the Court of Appeal, because we never made any promise that we are not going to file any further appeal. Any further appeal or any stay of execution at that stage, because our concern at that very moment is only in the stage of Sessions Court and the High Court, my lord.
It was not addressed. That issue was not addressed.
It's not addressed. It never been mentioned by any of the parties. Is that sufficient or anything else that my lord? Yeah. Can I proceed, sir?
Yeah. Yes. Please move.
My lord, I might want to address a little bit on the issue of the Reciprocal Enforcement of Judgment Act 1958, my lord.
Yeah.
Yes. It is undisputed facts that the plaintiffs are all the citizens of the Peoples of Republic of China, and insofar as the contents of the affidavits in support is concerned, we have in fact highlighted that one of the special circumstances which should be taken into consideration by the Honourable Court then was that should the money be released over to the plaintiff, we will not be able to recover back if there is any reversal of the judgment or order made by the Court of Appeal in our favour. So, insofar as the Reciprocal Enforcement of Judgment Act 1958, the Republic was never been one of the list under the
Not listed in the schedule.
Not listed, my lord. Not listed. And I do take cognizance of what my learned counsel for the plaintiff was saying just now based on the PNG oxygen case. But as what my lord Ya Arif Datuk Lee was saying just now, which my finding on this issue is that insofar as the China is concerned, their legal system is based on a civil law, my lord. So I don't think they are practicing a legal system based on the common law, because as rightly put Datuk Ya Arif Datuk Kamaluddin, they are not a Commonwealth country though. So we have put that in our affidavit to support the application. And I believe there is no reply made by the plaintiff in respect of that issue.
Their point is you should have gotten expert legal opinion from China, because we are not familiar with the civil system. But whichever system, whether it's common law or civil law based, I think it should yield a reasonable and just result. So the only problem would be the difficulty of recovering rather than the impossibility of recovering. But you should have advised or perhaps clarified the matter through an expert opinion from China.
But insofar as the the Act on the Reciprocal Enforcement of Judgment Act 1958 is concerned, which is Act 99, is clear-cut to say that they are not within the schedule. So as far as the law is concerned, it's quite clear-cut in and is already explained that we are not been able to enforce the judgment there.
So what you're
No,
saying?
there's another procedure. Go ahead.
So what you're saying is basically because it's not China is not part of REJA, so basically that by the cases here is a special circumstance.
It is, my lady.
Right.
It is one of the circumstances. Which features in this particular case.
Yeah, anything else?
Yes,
Mr. Azizi?
Yes, my lord. The last point, which my learned counsel, in reply to my learned counsel submission just now, is on the issue of public fund. Basically, the insurance company is actually a public company being supported with the stakeholders' money being entrusted to safeguard the monies from the public, because they are a public listed companies. They are gathering all
Mr. Azizi, if we go by that, then any public listed companies that apply for stay, we will have to grant. That would change the law. I don't think we should go down that road.
I mean, as far as the position is concerned, the money itself is a sanctity of the purview of the insurance company. So as far as the fund is concerned, obviously they have to safeguard the fund, my lord.
Are you saying that the public policy involved in basically it may affect the punya rates of payment, insurance payment?
Well, basically, I'm not in a position to say that, my lady. Yes.
Okay. So, anything else, Azizi?
Yes, I think that's about it.
Yeah. Okay.
Basically, Ya Arif, for the court, for the record of this court,
You have anything on the discretion of the High Court judge in granting the?
Yes, basically, Ya Arif, he has already taken all steps to on that issue, Ya Arif. Insofar as the High Court judge is concerned, he has not erred in granting the order for stay of execution, my lord. And I believe that he has exercised his discretion to allow the application. He has already based a proper deduction on the factual circumstances of this case. And insofar as the legal principle is concerned, he is applying the established legal principle of law based on the cases which I have submitted in my submissions, my lord, which falls within the ambit of Order 55, Rule 16.
Yes.
So in that event, I think he does not err in any way, either in facts or in law, my lord.
Okay. Yeah. Yeah. That's all?
I think, yes, I think that's about it. If there is nothing else from the panel.
Okay, thank you.
Thank you.
Mr. E, short reply.
Okay. Yang Arif, my learned friend have basically raised 5 issues. I like to reply to issue 1, 2, and 3. My learned friend submitted that there's no need to file a stay of execution at the session court level. And then my learned friend has also submitted that they have never bargained away the right of a stay. And my learned friend has also submitted that third issue that both parties didn't address the issue of stay of executions. I'd like to reply to these 3 issues. Well, Yang Arif, he goes back to the terms of the agreements. As Dato' Lee has rightfully pointed out, we look at the letters. The letters of the settlement agreements is meant to be read by any ordinary citizens. It's not. You don't have to write a super language, powerful language, or what kind of English, professor English level kind of language English. It's very clear cut. Upon disposal of the High Court, pay 50%. Clear cut. I advise my client, upon the High Court decisions, you get the balance 50%. Now my client is questioning me, isn't it the letter clear enough? So we don't have to bring this letter to go and show it to professor, lawyer, or whatever. We just show it to ordinary citizens on the street. Isn't it clear cut? Simple English, simple understanding, the terms of the agreements, layman's common sense readings. After the High Court appeal, you pay 50%. Likewise, I advise my client, after the High Court appeal, you get a 50%. Whether appeal further to court appeal, whether successful or not, that is another separate issue altogether.
But do you agree that the interpretation of the contract is up to the courts?
Of course, if there is a grey area in the terms of the settlement agreement, then of course the court will interpret. But there is nothing wrong in my agreement. It's very clear cut. Agreement is very clear. Upon disposal 50%, upon disposal of the High Court appeal, you get a balance 50%. Clear cut. Very clear. There is no grey area. And next, go back to the next issue of reciprocal of judgments. Yang Arif, the burden, let us, all of us don't speculate here. China may not practice common law. They are civil law. There's no doubt about it. But then, who knows? They have a procedures. They have a statute in China allowing recovery, allowing enforcement of foreign court judgments. You and I, we don't know. And for us to say that there's no way to get back the money in the China legal system, I don't think that is a fair statement. And that is a too simplistic approach. And furthermore, Yang Arif, in my affidavit of reply, my affidavit of reply is very simple. We don't need to look at whether China is a signatory to the reciprocal enforcement of judgment treaty or not. Because when you enter into this agreement, when you bargain this agreement, you were fully aware China was never a signatory to this reciprocal enforcement judgment treaty. You were fully aware of it. So it's too late right now for you to raise this argument.
Okay.
The next issue, the discretion of the High Court judge. Of course, the discretion of the High Court judge, they must look whether there is a special circumstances.
Yeah.
Here, the sanctity
well, very clear.
Yes.
Yes, on this.
The sanctity of the agreement, the terms of the agreement must be upheld. Number two, the discretions of the court must be exercised judicially in accordance to the principle of law. There is no signatory, there is no, China is not a treaty, it's not a member treaty to this, it's not a member country to this treaty, that does not constitute a special circumstances. There is no legal opinion from a China lawyer to say, no way the China court will recover, will enforce a Malaysian judgment. There is no such legal opinion.
Okay.
I think I've said enough.
Yeah.
I think I have addressed the issue, the main issue here.
We take note
So-
all the issues raised. We take note.
Unless there is any question from the panel, I'd be glad to answer.
Datuk Lee, any?
My Lord, I think it's quite imperative for me to highlight what is the amount that we are talking about at this point of time on the balance of that 50%. The one which is,
Half a million?
I think this one is, my Lord, for all three cases, the money which is in the stakeholder account of Mr. Key, KFE, is 1.583.
1.5, yeah, only 50 cents.
No, this is based on 50%. We have already released 1.3 million, and the balance now, as it stands, is 1.583. Yes.
Okay. We take note. Okay.
Short rebuttal. Irrespective of the amount,
Yeah.
it could be $3, it could be 3 million. It doesn't matter. We look at the terms of the agreement.
The principle, the law. Yeah. Okay, Mr. E. Okay. We have a short break for deliberation. We'll come back. Maybe let's say about 10-15 minutes. Okay, is it fine?
Dengan izin Yang Arif boleh mutekan kamera, boleh offkan kamera dan mutekan speaker.
Okay.
Terima kasih Yang Arif.
Datuk Lee is not here yet.
Yeah.
Ya, Arif Datuk Lee belum.
We thank Council for the able submissions, both oral and written. After considering the appeal records and submissions of both parties, and after our deliberation on the issues, all the issues ventilated before us, we have now reached to our decision, which is unanimous. We find no merit in the appeal. We also find no appealable error warranted an appellate intervention committed by the learned High Court judge in exercising his discretion in allowing the stay of execution of the judgment pending the disposal of the appeals before this court. We also find that there is no prejudice to the appellant as the money was placed in the appellant's council stakeholder as a stakeholder account, which bearing interest. And also we find that as China is not listed in the first schedule of the Act 99, it is a factor to be taken as a ground, a good ground for a conditional stay. Therefore, we dismiss the 3 appeals with cause and the cause of the main appeal. Decision of the High Court is affirmed. We thank Council for their cooperation. Thank you.
Very much.
Much obliged.
Thank you.
Ya, Arif boleh hang up. Terima kasih, Arif. Okay.
We forgot to address the issue of cost.
Cost in the cost of the main appeal.
Oh, cost in the cost.
Of the main appeal. Yes.
So I think thanks a lot, Puan Nur Saliha. Thanks a lot, Encik Azizis. Congratulations.
Thank you very much.
So I think
Terima kasih, Puan.
that's all. I think I can leave right now.
Okay.
Thank you very much.
Okay, thank you, James. Take care.
Selamat berpuasa.
Yes, thank you.
Easy. Tadi cost in the cost, right?
For the main appeal.
Kan?
Cost in the cost